just to explain, you've prosecuted many federal cases.
Right.
What is the bar? What if you're a career federal prosecutor, what is your duty to do when you prosecute a case? What's the first step?
Yeah, it's a really interesting question, Hugh, because it's more than just the legal standard there. The legal standard, theoretically, just to get the indictment is simply probable cause, which is, pretty low. There's the joke about how get the grand jury to indict a ham sandwich. That joke is because it's one-sided. The prosecutor goes in, there's no cross-examination, there's no opposing counsel. You just put on the case, sometimes just one question to your agent. That's what makes it relatively easy, practically, and the legal standard as well. But before you do that, you need to first present to your supervisors, typically in a prosecution memo. You lay out the pros and the cons in a more serious, complicated case, particularly if it's a case involving a very high-profile, politically charged situation. You want to run that up the chain, make sure everybody agrees with your assessments of that. And in your assessment of that, it's not even just the evidence. Again, the bare evidence might be, okay, it sounds like a crime if we prove it. Instead, the Justice Department has a manual that guides U.S. attorneys. You have to be certain that at trial, you could prove it beyond a reasonable doubt. So even though the legal standard for indictment is actually just probable cause, the real standard you're working with is proving this beyond a reasonable doubt. Then you say, yeah, I think we can do this at trial. Here's the evidence. Here's why. So those are the steps that you'd have to go through. And I'll add one more kind of twist in this tale, which is apparently they presented not 2, but 3 charges to the grand jury. And the grand jury only returned 2, meaning they did something called a declination on one of them. I can't tell you how rare that is, because you don't bring in charges, we'll just throw it up in the air and see what the grand jury does here. And for them to decline, in my 11 years at DOJ, I only saw 1 declination. And the other piece to it, which I'm not sure we covered as deeply in the piece I wrote, is the vote was also very weak.
Right.
You only need a majority, and they barely got the majority in those 2. Those 2 things would tell a prosecutor, this is a very poor case. I had cases where we had the votes, but back at the office talking to the supervisor, they're saying, you barely got the majority here. We either need to shore this up, or is it a signal it's just not a case worth bringing? So all those are very, very weak signals on this case.
So normally, this would be the subject of lots of discussion. They've got a weak case. Mm-hmm. But it looks here like the discussion is not about the weak case. The discussion is about going after one of Trump's enemies. Because, right, as you say, it seems that the career prosecutors, who are professionals, who, like you, serve regardless of the president, they serve regardless of who's holding the Senate or who's holding the House, they are there to serve the Constitution. Mm-hmm. They're not getting involved. Some of them have either fired or been left, or either left voluntarily or been fired. So this is now in the hands of people that are loyal to Trump, I think. Is that a fair summation of this case?
It seems more than fair, because also another unusual step was Ms. Halligan, as the new U.S. attorney, apparently personally presented the case to the grand jury. And that's extremely unusual. You wouldn't have like the top person. I mean, they have a lot of things to do, but they're actually showing up presenting the case. She also went to court when the indictment was returned to the magistrate judge. She had some snafus when she was there, probably due to inexperience, and haste makes waste. But the whole point here is, how come she was by herself? Maybe she wanted to get the credit of personally being there, but there's nobody else with her. And there is a suggestion there that she's having trouble finding the career people to do it. So that's highly unusual. And you've seen that a lot in the Trump DOJ, is top officials actually showing up in court to do the dirty work, the wet work. And that's very odd, because usually they're too busy. They're better qualified people who are really up on the case. So it could be a sign that they're really having trouble finding people.
So just spell out, what's the next steps in this case? James Comey has not yet appeared in court. So can you just explain, when's he going to be in court and what happens then?
Yeah, the next step is something they call an arraignment, and that's where he will show up in court. And I think that's coming up on the 8th or the 9th of October. and he'll be there with his lawyer or legal team. And it's a pretty straightforward process where the judge is simply letting him know he has these charges. His lawyer will typically waive a reading of the indictment, meaning we don't want to have the whole thing read to the world at this point. I mean, it's fine. There is an indictment. And then he'll plead not guilty. Everybody pleads not guilty the first time up. And then they'll set some schedules, which are important for pretrial motions. Maybe they'll pick a trial date, but definitely there'll be a schedule for pretrial motions. And this particular court, where they are, the Eastern District of Virginia, is nicknamed the Rocket Docket because they move very quickly. So I would watch for the judge to have them on a very tight timetable. We might even see a motion filed before then to seek to dismiss the case, but we're going to start to see a big flurry of the legal motions going back and forth now.
Now, when normally when these are filed, it's up to the judge, but this case may well go elsewhere, right? This is a case that raises a whole load of questions, potentially. Is it potentially possible for this to end up in front of the Supreme Court in some shape or form?
It's potentially possible. It would be really unusual for the criminal case at this stage to get there. I mean, generally speaking, you need something called a final determination in the case. There's got to be something dispositive in the case that's happened for it to be appealed. If, for example, there's a very nouveau type of argument made of immunity, as you saw in Trump's cases, then it might start to work its way up because the point would be we can't even get further in the case until we decide this. Here, the main argument Comey's people are probably going to make is selective prosecution, meaning he was picked out because he opposes Trump. Probably not going to go all the way to the court. Usually that would be heard at the district court level, the trial judge, and the judge rules one way or the other, and it's probably not going to keep going at this point. Later, it could be appealed. And I think you saw an example of that with the Hunter Biden situation, right, where he argued selective prosecution. But it'd be very rare to be able to stop the criminal case in its tracks and take it all the way up to the high court before you even finish the case.
Now, you wrote in your piece, which was a brilliant exposition of this case, about selective prosecution, and you pointed out it's not something that often gets raised, and even when it gets raised, it's not very likely to be successful. But this, right, again, seems a bit different.
Yeah, those are very hard cases to prove. I can't tell you how many clients I've had that say, I want this to be argued as selective prosecution. It's really hard standard to meet because the reason it's really hard practically is you have to show the malicious intent there. You have to somehow have proof that the prosecutors are saying, oh, we're going to pick you and other people, we usually don't pick them for the same kind of crime. And there has to be some idea that it's a little bit different than vindictive prosecution, which is where you've raised some argument and they're making it worse for you. Selective really goes to why they picked you. So you can imagine that prosecutors are not going to write down in their notes or emails to each other, we're going to get this guy, we're going to pick him because we really don't like him. They're not going to say that. But that's not true here because you have tons of statements from President Trump, from his White House officials, literally prejudging the case, saying what a terrible guy this is. He's a criminal. We got to get him. Telling Pam Bondi, the Attorney General of the United States, you got to get this guy. What's the delay here? That's what makes it such an unusually strong case for selective prosecution is you have all these public statements for them to go with. And that's really kind of unheard of. It's also good news for arguing there's terrible pretrial publicity that could prejudice the case as well, given who's talking about it.
Now, let's just explain pretrial publicity, right? We are talking about this trial, this case, it's getting publicity.
Right.
There's no reason not to. There's nothing wrong with that. The First Amendment allows that. But why? What's wrong with who is it that is forbidden from giving pretrial publicity? Who should not be talking about it?
Anyone who can strongly influence the court of public opinion, and here's what I mean by that. There's nothing wrong with publicity, and the key term in judging the fairness of something in legal cases is the word prejudicial. A lot of people will say that certain evidence shouldn't come in as prejudicial. Well, of course it's prejudicial because it helps one side or the other, but it's got to be wrongly prejudicial. It can't be just that I don't like it. So here, judges will sometimes say gag orders. They'll tell the prosecutors, I don't want to have you giving a press conference on the courthouse steps. Same thing with the defense counsel. And if it's a very notorious case, you're in a small town, there's been a murder, everyone's talking about it. And the defense counsel might say, we got to move this someplace else, and this whole community is abuzz with this. We can't get a fair trial here. Here, you'd have to move it, I don't know, some other universe, because there's no way to find a place where people haven't heard about it. And the problem here with that,
you need to find the place that has not heard of Donald Trump. That's
exactly
right. Okay.
And if we found that place, we can be sure that Trump would immediately fix that for us.
I think some people might be moving there. If you right. find it, I think we could set up. There'd be, it wouldn't be colonize Mars. I think there'd be an exodus. But
that's right. Yeah. That would work.
But that universe doesn't exist. So Donald Trump, all the times that he's called James Comey deranged and crooked and a liar, this is all going to be thrown into the court case, is what you would expect.
Exactly, because the argument will be this kind of statement from like the world's biggest bully pulpit is going to taint all of the jury pool. And it kind of works both ways, too. I mean, you certainly could have people who say, I can't stand, the president's remarks. I can't stand him. I don't care if it's his DOJ. I'm voting against them. So it works to both sides. But the defense is going to say these kinds of remarks, telling everybody they're prejudging the case. He's a terrible human being. That makes it impossible to get a fair trial any place on the planet, really. And that's the argument that's going to be made. Not as strong as the selective prosecution case, because as you're pointing out, of course, there's publicity in this case. And the judge will say, well, we can take care of that in jury selection. We'll ask a lot of questions, try and really ferret out the prejudices here. But it's definitely going to be a big issue.